Chapter 6 Introduction to the Legal System *RM WV Vave greater than Chapter Outline A. Federalism, Checks and Balances, and Paralegals B. Common Law, and our Adversarial System C. Judicial Systems D. Administrative Agencies E. The Legislative Process. Accountability L system R section / phi DIRAUSN / Checks and Balances, and Paralegals Federalism the division of powers between the federal government and the state governments. Legislative branch the branch of government with primary responsibility for making or enacting the law. Executive branch the branch of government with primary responsibility for carrying out, executing, or administering the laws. Judicial branch the branch of government with primary responsibility for interpreting laws by resolving disputes that arise under them. Checks and balances an allocation of governmental powers, whereby one branch of government can block, check, or review what another branch wants to do or has done, in order to maintain a balance of power among the legislative, executive, and judicial branches. What are the components of our legal system, and what kind of laws do they produce? These are our concerns in this chapter, as we continue to explore the role of the paralegal. Our legal system consists of 3 levels of government. The federal government, also called the national government or the United States government, 50 state governments, and a large variety of local governments called counties, cities, and townships. Accountability L system R section / phi DIRAUSN / Checks and Balances, and Paralegals Federalism the division of powers between the federal government and the state governments. Legislative branch the branch of government with primary responsibility for making or enacting the law. Executive branch the branch of government with primary responsibility for carrying out, executing, or administering the laws. Judicial branch the branch of government with primary responsibility for interpreting laws by resolving disputes that arise under them. Checks and balances an allocation of governmental powers, whereby one branch of government can block, check, or review what another branch wants to do or has done, in order to maintain a balance of power among the legislative, executive, and judicial branches. What are the components of our legal system, and what kind of laws do they produce? These are our concerns in this chapter, as we continue to explore the role of the paralegal. Our legal system consists of 3 levels of government. The federal government, also called the national government or the United States government, 50 state governments, and a large variety of local governments called counties, cities, and townships. Of these 3 levels, the most important are the federal government and the state governments. To a large extent, local governments are dependent on, even though, in many respects, they are separate from state governments. A division of powers exists between the federal government and the state governments. Only the federal government, for example, has the power to declare war, whereas only a state government has the power to issue a marriage license or a divorce decree. Some powers are shared among these levels of government. In the area of public assistance or welfare, for example, both the federal government and the state governments play major roles. The term federalism refers to the division of powers between the federal government and the state governments. Federalism simply means that we live in a society where some powers are exercised by the federal government, others by the state governments, and still others by both the federal and the state governments. Within the federal, state, and local levels of government, there are 3 branches. One that makes laws, legislative branch, one that carries out laws, executive branch, and one that interprets laws by resolving disputes that arise under them, judicial branch. The categories of law that these 3 branches of government write are outlined in Exhibit 6.1. Here is an overview of our 3 levels of government and the 3 branches that exist at each level. Federal government, legislative branch. The Congress, executive branch. The President and the federal administrative agencies. See the chart in Appendix D. Judicial branch. the U.S. Supreme Court, the U.S. Courts of Appeals, the U.S. District Courts, and other federal courts. See Exhibits 6.3 and 6.4. State Government Legislative Branch. The State Legislature Executive Branch. The Governor and the State Administrative Agencies Judicial Branch. The State Courts. See Exhibit 6.2. Local Government Legislative Branch. The City Council, or County Commission Executive Branch. The Mayor or County Commissioner, and the Local Administrative Agencies Judicial Branch. The local courts. Some local courts, however, are considered part of the state judiciary, in addition to the division of power between the federal and state levels of government. There is a division of power among the three branches, legislative, executive, and judicial, within each level. This division is called the system of checks and balances, and is designed to prevent any one branch from becoming too powerful. The system allocates governmental powers among the three branches. One branch is allowed to block, check, or review another branch so that a balance of powers is maintained among the branches. Let's look at an example. The legislative branch has the primary responsibility for writing the law. By majority vote, the legislature creates what are called statutes. See Exhibit 6.1. But there are significant checks on this power. First of all, the chief executive must give final approval to a proposed law before it can become a statute. He or she can veto, i.e. reject, the proposed law. The legislature, however, has another power that operates as a counter-check on the chief executive's power to veto proposed laws. The legislature can override, i.e. nullify the Exhibit 6.1 kind S of laws category definition. Who writes this kind of law? Example opinion, a court's written explanation. Courts, the judiciary. The in the Opman-Jackson v. of how it applied the law to courts that write most of the IBM. The Court of Appeals, the facts before it to resolve opinions. Our courts have affirmed the trial court, legal dispute. Also called appeal, also called appellate ruling, that Jackson had case. The word case has, two courts, not been fired because of other meanings. Appending his race. Matter on a court calendar, and a client matter, handled by a law office. B statute, a law that declares the legislature. Some states 200 OFTITLE 4 OFTHE commands, or prohibits. Also allow direct vote of statutory code requires something. Also called the people by referendum corporations, to file biannual legislation. An act is the finance statements, with the official document, that Secretary of State, contains the statute. See Constitution, the fundamental law, that varies. Often a combination, 7 of Article 1, of the creates the branches of the legislature, and a vote. Constitution provides that all government, and identifies of the people. Another bills for raising revenue, shall basic rights and obligations option, might be originate in the House of Constitutional Convention. Representatives. D. Administrative, a law designed to explain, or administrative agency. 16 of the administrative regulation, carry out the statutes, and code provides that all finance executive orders that govern statements filed pursuant to an administrative agency. 200 of the statutory code, also called an administrative, shall be accompanied by a Rule $75 filing fee. Administrative, a resolution of a controversy. Administrative agency. In Sec v. Forbes and Shelton, decision between a party and in the Securities and Exchange Administrative Agency Commission, brought in involving the application of enforcement action, charging the regulations, statutes, or that corporate officials had executive orders that governed committed financial fraud. The agency, also called an administrative ruling. F. Charter, the fundamental law of a varies. The state legislature 160 of the municipal charter. Municipality, or other local often writes charter, provides that applicants, for unit of government provisions, for cities in the position of city clerk, with authorizing it to perform. State the 3 highest scores, on designated governmental. The civil service test, shall be functions interviewed within 30 days, of the receipt of the test scores. I.LLILLR/K./LH.LIX nil. LL.CalSVBLLM Exhibit 6.1 Kind S of laws. Continued category definition. Who writes this kind of law? Example G. Ordinance, a law that declares the local legislature, e.g., 10.51 of the revised commands, or prohibits. City council, county municipal code provides something. Same as a commission. that telecommunications stature, but at the local level. Companies must obtain a private use permit when seeking to use any public right-of-way within city limits. H. Rules of Court, the procedural laws that varies. The Legislature Superior Court Rule 9c govern the mechanics of and/or the highest court and provides that opposing litigation practice and the jurisdiction. Counsel shall confer in procedure, before advance of filing, any motion particular court, also called in a good faith effort to court rules narrow areas of disagreement pertaining to the motion. I. Executive Order Law, issued by the Chief President for U.S. Executive Order No. 22 Executive pursuant to specific government. Governor for directs the Department of Statutory Authority, or to the state government. Mayor Education to complete executive's inherent authority for local government. Within 6 months to direct the operation of comprehensive review of all governmental agencies' vendor contracts, involving a payment of $5,000 or over. J. Treaty and international agreement. The President makes treaties. Article 9 of the extradition between two or more by, and with the consent of treaty, between the United Nations or sovereigns. Also the U.S. Senate, if the states and Mexico provides, called a convention. President has the authority that neither country is to enter the agreement, bound to deliver up its own without Senate approval, it nationals, but that each is called an executive country, has the discretion to agreement do so. K. Opinion of the formal legal advice given by Attorney General. Attorney General opinion. Attorney General, the chief law officer of the sometimes called 90 pounds 39, concluded that the government, to another legal counsel, phrase teacher's contract, government official or in 65c of the statutory agency. Technically, this is code did not apply to not a category of law, but it is teachers hired for temporary, often relied on as a source summer positions, of law. Judicial review. The power of a court to determine the constitutionality of a statute or other law, including the power to refuse to enforce it. If the court concludes that it violates the Constitution, chief executive's veto, by a 2/3 vote. These are some of the ways that the legislative and executive branches check each other. The judiciary branch has a similar function. Courts can check the legislative and executive branches through the power of judicial review. This is the power to refuse to enforce a law because it is in conflict with the Constitution. In turn, the judicial branch can be checked by the other branches. For example, the legislature controls the budget of the courts, and the chief executive often nominates the persons who will be judges. The result of all these checks and counter-checks is a balance of power among the three branches so that no one branch becomes too powerful. How do paralegals fit within these levels and branches of government? First of all, many paralegals are civil service employees of government, particularly in federal, state and local administrative agencies. See Appendix 2.b in Chapter 2. To a more limited extent, paralegals are also employees of legislatures and courts. Second, paralegals help attorneys solve the legal problems of clients by applying the different kinds of law outlined in Exhibit 6.1 to the facts presented by client cases. A single case can involve the laws of different levels and branches of government. For example, Linda Thompson applies for unemployment compensation benefits after being terminated from her job. Her former employer says the termination was due to a slowdown in business at the company. Linda believes she was let go because she is a woman and because she is HIV positive. You are a paralegal working for Sims &Sims, which represents her. Your supervisor may ask you to undertake a variety of tasks: interviewing, investigation, research, analysis, drafting, law office administration, etc. A central focus of everything the attorney and paralegal do on such a case is the application of laws to the facts of the case. The laws are written by different branches of government at the different levels of government. Here are some examples of laws that might apply to Linda Thompson's case. The 14th Amendment of the United States Constitution, guaranteeing equal protection of the law. Federal statutes on civil rights, sex discrimination, disability discrimination, evidence and civil procedure in federal courts, etc. Opinions of federal courts on civil rights, sex discrimination, disability discrimination, evidence, civil procedure in federal courts, etc. Administrative regulations on sex discrimination of the U.S. Equal Employment Opportunity Commission and other federal administrative agencies. The Equal Rights Amendment of the state constitution prohibiting sex discrimination. State statutes on unemployment compensation, civil rights, sex discrimination, evidence and civil procedure in state courts, etc. State court opinions on unemployment compensation, civil rights, sex discrimination, evidence and civil procedure in state courts, etc. Administrative regulations on unemployment compensation of the State Unemployment Compensation Commission. These, then, are the major laws and institutions involved in the practice of law. We can say that our legal system is an organized method of resolving legal disputes and achieving justice through the interpretation and enforcement of laws written by different levels and branches of government. To participate, paralegals need to have a basic understanding of the essential components of this process. The chapters in Part 2 of this book are designed to provide this understanding. Assignment 6.1. Find a recent article in your local general newspaper that meets the following criteria. A. It refers to more than one kind of law listed in Exhibit 6.1, and B. It refers to more than one level of government. The article will have no formal citations to laws, so do the best you can to guess what kinds of law and levels of government are involved. Clip out the article. In the margin, next to each reference to a law, place the appropriate abbreviation. FO if you think the reference is to a federal court opinion. So if you think the reference is to a state court opinion. FS Federal Statute. SS State Statute. FC United States Constitution. SC State Constitution. FAR Administrative Regulation of a federal agency. SAR Administrative Regulation of a state agency. Make up your own abbreviations for any other kind of law listed in Exhibit 6.1. If the article refers to the same law more than once, make a margin note only the first time the law is mentioned. We'll have an informal contest to see which student can find the article with the most different kinds of laws involving more than one level of government. Liipakai.kel until legal system R section 15 common law and over AI greater than adversarial system common law 1 court opinions all of case law 2 the legal system of England and of those countries such as the United States whose legal system is based on England's. 3. The case law and statutory law in England and in the American colonies before the American Revolution. 4. Judge-made law in the absence of controlling statutory law or other higher law. Civil law system the legal system of many Western European countries other than England that place a greater emphasis on statutory or code law than do countries such as England and the United States whose common law system places a greater emphasis on case law. At common law all the case law and statutory law in England and in the American colonies before the Revolution precedent a prior decision that can provide some guidance for the resolution of a current dispute before the court. Stare decisis courts should decide similar cases in the same way, unless there is good reason for the court to do otherwise. A reluctance to reject precedent prior opinions. Cause of action A. Legally acceptable reason for suing. Facts that give a party the right to judicial relief. Before examining the components of our judicial system, we need to understand two of its critical characteristics. First of all, the system is based on the common law. This phrase has at least 4 meanings, the last of which will be our primary concern in this book. At the broadest level, common law simply means case law court opinions as opposed to statutory law. In this sense, all case law develops and is part of the common law. Common law also refers to the legal system of England and the United States. Its counterpart is the civil law system of many Western European countries other than England. The origin of civil law includes the jurisprudence of the Roman Empire set forth in the Code of Justinian. Many civil codes in Europe other than England have been greatly influenced by the Code Napoleon of France. Both the common law system and the civil law system rely on statutory codes and on case law. The difference is primarily one of emphasis. In a common law system, the role of case law is greater than it is in a civil law system. On the other hand, in a civil law system, statutory or code law has greater prominence than it does in a common law system. 49 states in the United States have a common law system. Louisiana is unique in that its law is largely based on the civil code, due to the historical importance of France in that state. More narrowly, common law refers to all of the case law and statutory law in England and in the American colonies before the American Revolution. The phrase "at common law" often refers to this colonial period. The most prevalent definition of common law is judge-made law, in the absence of controlling statutory law or other higher law. Courts are sometimes confronted with disputes, for which there is no applicable law. There may be no constitutional provisions, statutes, or administrative regulations governing the dispute. When this occurs, the court will apply, and if necessary, create common law to resolve the controversy. Here common law is used in the fourth sense given above. That is, it is made by judges, to compensate for the lack of statutory and other law applicable to the case at hand. In creating the common law, the court relies primarily on the unwritten customs and values of the community from time immemorial. Very often these customs and values are described and enforced in old opinions that are heavily cited by modern courts in the continuing process of developing the common law. The common law grows slowly, case by case. Radical changes are not encouraged, and therefore, are relatively rare. Once a court decides a case, it becomes a potential precedent that can be helpful for the resolution of similar cases that arise in the future. Under the doctrine of stare decisis, a court will decide similar cases, in the same way, i.e., it will follow available precedents unless there is good reason for the court to do otherwise. Courts are most comfortable when they can demonstrate that their decisions are rooted in precedent. Knowing this, attorneys and paralegals study precedents in order to try to predict how a court might resolve a current case. Suppose, for example, that a law firm is representing a client who is being sued for battery, which is a common law cause of action. He took a baseball bat and forcefully hit the handlebars of a bicycle on which the plaintiff was riding at the time. The bat did not touch the plaintiff's body. This case raises the question of whether you can batter someone without making contact with his or her body. One of the steps the law firm will take in representing this client is to do legal research in order to try to find precedents for this kind of case. Assume that on the shelves of the law library or in an online legal database the attorney or paralegal finds the prior case of Harrison P. Liner. This case held the defendant committed a battery when he knocked over a plate being held by the plaintiff, even though the defendant never touched any part of the plaintiff's body. Is Harrison v. Liner a precedent for the bicycle case? Is hitting a bicycle handle with a bat sufficiently similar to knocking a plate out of someone's hand? The law firm must predict whether a court will apply Harrison v. Liner to the bicycle case, making such a prediction requires legal analysis, which we will be studying in Chapter 7. For our purposes, the example illustrates how precedent is used in our common law system. When the bicycle case goes before the court, the attorneys for both sides will be spending a good deal of time trying to convince the court that Harrison v. Liner is or is not a precedent. Note that the fourth definition of common law says judge-made law, in the absence of controlling statutory law or other higher law. As we will learn in Chapter 1:1, there is a hierarchy in the categories of law. Constitutional law, for example, is higher in authority than statutory law. So too, statutory law is higher in authority than common law. Assume that the courts have created common law in an area where no controlling statutes existed. This does not mean that statutes can never play a role in this area. The legislature can now decide to step in and create statutes that change the common law in this area. Such statutes are said to be in derogation of the common law. One of the best examples of the interplay between common law and statutory law can be found in the area of contracts. A great deal of contract law was created by the courts as common law. Centuries ago, for example, the courts created the principle that a contract was not enforceable unless it was supported by consideration. Over the years, statutes have been written to change many common law contract principles. In some kinds of contracts, for example, statutes have changed the common law of consideration. For commercial contracts, the greatest statutory changes were brought about by the Uniform Commercial Code. Many other contract statutes, in derogation of the common law, also exist. Today, contract law consists of a mix of statutes and those common law principles that have not been changed by legislatures, or indeed by the courts themselves, who are always free to change their own common law. This evolution of the common law has been taking place for centuries and has given us what commentators call the seamless web of the common law. The second critical characteristic of our judicial system is that it is adversarial. An adversarial system is a form of head-to-head combat. If a dispute arises, you get everyone in the same room and have them fight it out in the open. This approach is based on the theory that justice and truth have a greater chance of being achieved when the parties to a controversy appear on their own, or through a representative or advocate, before a neutral judge, to present their conflicting positions. We don't expect the judge to control the case by calling and questioning the witnesses. By and large, we leave this to the parties and their representatives. Ideally, the parties have an equal opportunity to present their case to the decision maker. Unfortunately, the system is often criticized for failing to live up to this ideal. In many disputes between a citizen and a corporation, for example, the citizen cannot afford the kind of representation available to the corporation adversarial, involving the presence of an opponent or adversary. Our section C Judicial Systems. The lifeblood of a court is its jurisdiction. After examining the nature of jurisdiction, our goal here will be to identify the major courts that exist and to explore how they are interrelated. 1. Jurisdiction. There are 50 state court systems, and one main federal court system. Each court within a system is identified by its jurisdiction to adjudicate, i.e., resolve through litigation, a legal dispute brought before it. When referring to the courts, the word jurisdiction has two major meanings. First, it refers to the power of the court over the persons, or over the property, involved in the litigation. Power over the person is called personal jurisdiction, also in personam jurisdiction. If the court is not able to obtain personal jurisdiction over the defendant, it still may be able to make an order over a particular thing called the res, located within the territory over which the court has authority. An example of a res would be land. The jurisdiction that a court needs to render a judgment over such a res is called in rem jurisdiction. Everyone with an interest in the res, e.g. anyone who claims to own all or a part jurisdiction, power, or authority to act, adjudicate, to use a court or other tribunal to resolve a legal dispute through litigation. The noun is adjudication. The adjective is adjudicative. Personal jurisdiction, the court's power over a particular person. In rem jurisdiction, the court's power over a particular thing. Res, located within the territory over which the court has authority. Subject matter jurisdiction, the power of the court to resolve a particular category of dispute. Limited jurisdiction, the power of a court to hear only certain kinds of cases. Also called special jurisdiction. General jurisdiction, the power of a court to hear any kind of civil or criminal case, with certain exceptions. State questions, issues or questions that arise from or that are based on the state constitution, state statutes, state administrative regulations, state common law, or other state laws. Federal questions, issues or questions that arise from or that are based on the federal constitution, federal statutes, federal administrative regulations, or other federal laws. Exclusive jurisdiction, the power of a court to hear a particular kind of case to the exclusion of other courts. Concurrent jurisdiction, the power of a court to hear a particular kind of case along with other courts that could also hear it. Original jurisdiction, the power of a court to hear a particular kind of case initially. A trial court. Appellate jurisdiction, the power of a court to hear an appeal of a case from a lower tribunal, e.g., a lower court or administrative agency, to determine whether the lower tribunal committed any errors of law. Of it, and not just those over whom the court has personal jurisdiction, must obey the judgment of a court within rem jurisdiction. Second, jurisdiction means the power that a court must have over the subject matter, or over the particular kind of dispute that has been brought before it. Some of the more common classifications of subject matter jurisdiction are limited jurisdiction, general jurisdiction, exclusive jurisdiction, concurrent jurisdiction, greater than original jurisdiction, appellate jurisdiction. Limited jurisdiction. A court of limited or special subject matter jurisdiction can hear only certain kinds of cases. A criminal court is not allowed to take a non-criminal case, and a small claims court is authorized to hear only cases in which the plaintiff claims a relatively small amount of money as damages from the defendant. The maximum amount a small claims court can award is set by statute. B. General jurisdiction. A court of general jurisdiction can, with some exceptions, hear any kind of civil or criminal case. Here, the word quil means pertaining to a private right or matter. A state court of general jurisdiction can handle any case that raises state questions, i.e. questions arising from or based on the state constitution, state statutes, state regulations, state common law, or other state laws. A federal court of general jurisdiction can handle any case that raises federal questions, i.e. questions arising from or based on the federal constitution, federal statutes, federal regulations, or other federal laws. C. Exclusive jurisdiction. A court of exclusive jurisdiction is the only court that can handle a certain kind of case. For example, a juvenile court may have exclusive jurisdiction over all cases involving children under a certain age who are charged with acts of delinquency. If this kind of case is brought in another court, there could be a challenge on the ground that the court lacked jurisdiction over the case. D. Concurrent jurisdiction. Sometimes, two courts have jurisdiction over a case. The case could be brought in either court. In such a situation, both courts are said to have concurrent jurisdiction over the case. For example, a family court and a county court may have jurisdiction to enforce a child support order. Original jurisdiction. A court of original jurisdiction is the first court to hear a case. It is also called a trial court or a court of first instance. In addition, it is a court of limited jurisdiction if it can try only certain kinds of cases, or of general jurisdiction if it can try cases involving any subject matter, or of exclusive jurisdiction if the trial can take place only in that court, or of concurrent jurisdiction if the trial can take place either in that court or in another kind of court. F. Appellate jurisdiction. A court with appellate jurisdiction can hear appeals from lower tribunals, e.g., a lower court, an administrative agency, to determine whether the lower tribunal committed any error of law. For example, at the federal level, the United States Supreme Court has appellate jurisdiction to review a decision of a United States Court of Appeals. Similarly, at the state level, the New York Court of Appeals has appellate jurisdiction to review a decision of a lower New York State Court. The re-examination of what the lower tribunal has done is called a review. Sometimes a party who is dissatisfied with a lower court ruling can appeal as a matter of right to the appellate court. The court must hear the appeal. In other kinds of cases, the appellate court has discretion as to whether it will hear the appeal. 2. State court systems. First, we examine jurisdiction in our state courts. See Exhibit 6.2a. Courts of original jurisdiction. A state will have one or more levels, or tiers of trial courts. Courts of original jurisdiction. These courts hear the dispute, determine the facts of the case, and make the initial determination, or ruling. In addition, they may sometimes have the power to review cases that were initially decided by an administrative agency. The most common arrangement is a two-tier system of trial courts. At the lower level are courts of limited or special jurisdiction, the so-called inferior courts. Local courts, such inferior court A, lower court of limited or special jurisdiction. Exhibit 6.2 Hierarchy of state judicial systems. Level of name S of court. At this function of court, at this level court level in different states, and the lines of appeal. The Court of Final Supreme Court, Suprema Judicial. This court has appellate jurisdiction. Resort. The highest court, Supreme Court of Appeals. It hears appeals from lower courts in the state court of appeals state. If the state has intermediate appellate court system courts, appeals are heard from these courts. If intermediate appellate courts do not exist in the state, the highest state court hears appeals directly from trial courts. Intermediate Court of Appeals, Court of Civil. This court has appellate jurisdiction. Appellate courts. Appeals, Court of Criminal. It hears appeals from trial courts. Exist in about half appeals. Appellate court, appeals state. If the state does not have the state's court, District Court of Appeals. Intermediate appellate courts, appeals go Intermediate Court of Appeals directly from the trial court to the Court of Court of Special Appeals, Final Resort. Appellate Division of Superior Court. Trial Courts. Tier 1 Superior Court, Circuit Court. This is a trial court of general jurisdiction. District Court, Court of Common Cases. From these courts are appealed to the pleas in New York. The trial court intermediate appellate courts in the state if at this level is called the Supreme. The state has intermediate appellate courts. Court if the state does not have such courts, cases are appealed to the Court of Final Resort. Trial Courts. Tier II Probate Court, Small Claims. This is a trial court of limited jurisdiction. Court Family Court, Municipal examples. The probate court hears estate court, county court, district cases of deceased or incompetent persons. Court, Justice of the Peace Court, the Small Claims Court, hears cases. Police Court, City Court, water involving small amounts of money damages. Court Trial Courts, at this level are the Family Court, hears divorce custody. Sometimes called inferior courts, and other domestic relations matters. The Municipal Court hears traffic cases, and those involving petty crimes cases, from trial courts of limited jurisdiction, are often appealed to trial courts of general jurisdiction. Some, however, are appealed to the intermediate appellate courts if they exist, or to the Court of Final Resort. P.Tilly/I Systemicity Courts, County Courts, Small Claims Courts, or Justice of the Peace Courts often fall into this category. These courts may have original jurisdiction over relatively minor cases, such as violations of local ordinances, and lawsuits involving small sums of money. Also included in this category are special courts that are limited to specific matters, such as surrogate courts or probate courts that hear matters involving the estates of deceased or mentally incompetent persons. Immediately above the trial courts of limited jurisdiction are the trial courts of general jurisdiction, which usually handle more serious cases, such as lawsuits involving large sums of money. The name given to the trial courts at this second level varies greatly from state to state. They are known as superior courts, courts of common pleas, district courts, or circuit courts. New York is especially confusing. There, the trial court of general jurisdiction is called the Supreme Court, a label reserved in most states for the Court of Final Appeals, the highest court in the system. Not all states have a two-tier trial system. Some states do not have inferior courts of limited jurisdiction. They have only one court of original jurisdiction. Moreover, the individual levels may be segmented into divisions. A court of general jurisdiction, for example, may be broken up into specialized divisions, such as landlord-tenant, family juvenile, and criminal divisions. Appellate brief: a document submitted by a party to an appellate court and served on the opposing party, in which arguments are presented on why the rulings of a lower court should be approved, modified, or reversed. Panel: a group of judges, usually 3, who decide a case. See the glossary for other meanings of panel. En banc: by the entire court. Court of Final Resort, the highest court within a judicial system. B. Courts of Appeals. A court of appeals, also called an appellate court, has appellate jurisdiction. This allows it to review decisions of a lower tribunal, in order to determine whether that lower tribunal committed any errors of law, by incorrectly interpreting, or applying the law, to the facts of the dispute. In this review process, appellate courts do not make their own findings of fact. No new evidence is taken, and no witnesses are called. The court limits itself to an analysis of the trial court record, consisting of transcripts of testimony, copies of the various documents that were filed, etc., to determine if that lower court made any errors of law. Attorneys submit appellate briefs containing their arguments on the correctness or incorrectness of what the lower court did. An appellate court often consists of an odd number of justices, e.g. 5, 7, 9, 1, 1, 15. This helps avoid tie votes. Some of these courts hear cases in smaller groups of judges, usually 3. These groups are called panels. Once a panel renders its decision, the parties often have the right to petition to the full court to hear the case en banc, meaning with the entire membership of the court. Many states have only one level of appellate court to which trial court judgments are appealed. About half the states have 2 levels or tiers of appellate courts. The first level is the Court of Middle Appeals, sometimes called an intermediate appellate court. The decisions of this court can in turn be reviewed by the Court of Final Appeals. This latter court, often known as the Supreme Court, is the court of final resort. As indicated in Exhibit 6.2, about half the states do not have intermediate appellate courts. Appeals from trial courts in such states go directly to the court of final resort. Assignment 6.2 redo Exhibit 6.2 so that your chart includes all the state courts of your state. Identify each level of state court in your state using Exhibit 6.2 as a guide. Give the complete name of each court you include and a one-sentence description of its subject matter jurisdiction. Indicate the lines of appeal among these courts. To find out what state courts exist in your state, check your state statutory code and your state constitution. This is the only way to obtain current information about your state court system. You may come across a chart written by someone else, but it may not reflect recent changes in the structure and names of your state courts. B. Select any state trial court of general jurisdiction in your state. State its name, address, and phone number. Include the email address and the worldwide website if the court has either. Also state the name, phone number, and fax number of the chief clerk of this court. C. Give the name, address, and phone number of the court to which decisions of the trial court you selected are appealed. Include the email address and the worldwide website if the court has either. Also state the name, phone number, and fax number of the chief clerk of this appellate court. 3. Federal court system. The federal court system, like the state systems, consists of two basic kinds of courts: courts of original jurisdiction, trial courts, and appellate courts. See Exhibit 6.3. Courts of original jurisdiction. The basic federal court, at the trial level, is the United States District Court. There are districts throughout the country, at least one for every state: the District of Columbia, Guam, the Virgin Islands, and Puerto Rico. The district courts exercise general, original jurisdiction over most federal litigation, and also serve as courts of review for many cases initially decided by federal administrative agencies. In addition to the district courts, several federal courts, such as the United States Court of Federal Claims and the United States Bankruptcy Court, exercise original limited jurisdiction over specialized cases. United States District Court, the main trial court in the federal judicial system. B. Courts of Appeals. The federal system, like almost half of the 50 state judicial systems, has two levels or tiers of appellate courts: intermediate appellate courts and the court of final resort. The primary courts, at the intermediate appellate level, are the United States Courts of Appeals. These courts are divided into 12 geographic circuits, 11 of them made up of groupings of various states and territories, with the 12th for the District of Columbia. Their main function is to review the decisions of the federal courts of original jurisdiction, primarily the United States Court of Appeals, the main intermediate appellate court in the federal judicial system. Exhibit 6.3 Hierarchy of the Federal Judicial System. United States Court of Appeals. For the Armed Forces Supreme Court of the United States. United States Courts of Appeals. 1 for each of 12 geographic circuits. Federal administrative agencies. Examples: Federal Trade Commission, National Labor Relations Board, Immigration and Naturalization Service. United States Tax Court. United States District Courts, 94 districts in 50 states. T. District of Columbia, Puerto Rico, etc. United States Court of Appeals. 14 Federal Circuit. United States Court of Federal Claims. United States Court of International Trade. United States Court of Appeals for Veterans Claims. United States Supreme Court, the court of final resort in the federal judicial system. District courts. In addition, decisions of certain federal agencies, notably the National Labor Relations Board, are reviewed directly by a court of appeals, without first going to a district court. Finally, there is a specialized court of appeals, called the Court of Appeals, for the Federal Circuit. This court reviews a. decisions from the United States Court of Federal Claims, the United States Court of International Trade, and the United States Court of Appeals for Veterans Claims, and b. some decisions of the district courts, where the United States government is a defendant. The Federal Court of Final Resort is, of course, the United States Supreme Court, which provides the final review of the decisions of all federal courts and agencies. The Supreme Court may also review certain decisions of the state courts when these decisions raise questions involving the United States Constitution, a federal statute, or other federal law. Exhibit 6.4 illustrates the division of the federal court system into 12 geographic circuits. Each circuit has its own United States Court of Appeals. The United States District Courts exist within these circuits. Assignment 6.3 What is the complete name of the federal trial court that covers where you live? Give its address and phone number. Include the email address and the worldwide website if the court has either. Also state the name, phone number, and fax number of the chief clerk of this court. B. What is the name of the United States Court of Appeals to which decisions of your federal trial court are appealed? Give its address and phone number. Include the email address and the worldwide website if the court has either. Also state the name, phone number, and fax number of the chief clerk of this appellate court. Administrative agency: a unit of government that carries out or administers the statutes of the legislature and the executive orders of the president, governor, mayor, or other chief executive of the executive branch. \section DADMINISTRATPV Agencies. An administrative agency is a unit of government whose primary mission is to carry out or administer the statutes of the legislature and the executive orders of the chief of the executive branch of government. At the federal level, the chief is the president. At the state level, it is the governor. And at most local levels, it is the mayor. As we will see in a moment, many agencies do more than carry out or execute the law. They also have closely related rulemaking and dispute resolution responsibilities. Administrative agencies can have a wide variety of names. Here are some examples: Fire Department, Board of Licenses and Occupations, Civil Service Commission, Agency for International Development, Department of Defense, Office of Management and Budget, Legal SER/ICES, Corporation, Bureau of Taxation, Internal Revenue SER/ICE, Division of Child Support and Enforcement, Social Security Administration. Certain types of agencies exist at all three levels of government. For example, there is a separate tax collection agency in each of the federal, state, and local governments. Other agencies, however, are unique to one of the levels. For example, only the federal government has a Department of Defense (DoD) and a Central Intelligence Agency (CLA). Nothing comparable exists at the state and local levels of government. The latter have police departments and the highway patrol, but their role is significantly different from the DoD and CIA. For a list of some of the most important federal agencies, see Appendix D. Executive Department Agency. An administrative agency, CHAT, exists within the executive branch of government, often at the cabinet level. Independent Regulatory Agency, an administrative agency that regulates an aspect of society. It often exists outside the executive branch of government. Quasi-independent regulatory agency, an administrative agency that has characteristics of an executive department agency and an independent regulatory agency. Government corporation, an entity that is a mixture of a corporation and a government agency, created to serve a predominantly business function in the public interest. Quasi-legislation, an administrative regulation enacted by an administrative agency that has some characteristics of the legislation, i.e. the statutes enacted by the legislature. Quasi-adjudication, an administrative decision written by an administrative agency that has some characteristics of an opinion written by a court. Administrative law judge, ALJ, a government official at an administrative agency who presides over a hearing to resolve a legal dispute. There are three main kinds of administrative agencies: executive department agencies, independent regulatory agencies, quasi-independent regulatory agencies. Executive department agencies exist within the executive branch of the government, often at the cabinet level. Examples include the Department of Agriculture and the Department of Labor. These agencies are answerable to the chief executive, who usually has the power to dismiss those in charge of them. Independent regulatory agencies exist outside the executive department, and therefore, outside the day-to-day control of the chief executive. Examples include the Securities and Exchange Commission and the Public Utilities Commission. Their function is usually to regulate an aspect of society, often a particular industry such as securities and public utilities. To insulate these agencies from politics, those in charge usually cannot be removed at the whim of the chief executive. A quasi-independent regulatory agency is a hybrid agency, often with characteristics of the two kinds just described. It has more independence than an executive department agency, yet it might exist within the executive department. An example is the Federal Energy Regulatory Commission, which exists within the United States Department of Energy. In a category all its own is the government corporation. This is an entity that has characteristics of a corporation and a government agency. It is designed to have considerable flexibility and independence in carrying out a predominantly business function in the public interest. Examples include the Tennessee Valley Authority, the United States Post Office, and the Corporation for Public Broadcasting. The government establishes this entity and usually provides its initial funding. Often, however, its ongoing budget comes from fees and private charitable giving. Members of the boards of directors of government corporations are usually appointed by the President and confirmed by the Senate. Many administrative agencies have three functions: execution, rulemaking, and dispute resolution. Execution. The primary function of the agency is to execute, i.e., carry out the statutes governing the agency and the administrative regulations created by the agency itself. This is the agency's executive function, rulemaking. The agency often has the authority to write rules and regulations. See Exhibit 6.1 for a definition of administrative regulation. In so doing, the agency is making law, like a legislature. Indeed, such laws are often referred to as quasi-legislation. Dispute resolution. The agency has the authority to interpret the statutes and regulations that govern it. Furthermore, it often has the authority to resolve disputes that arise over the application of such laws. It will hold administrative hearings and issue decisions. See Exhibit 6.1 for a definition of administrative decision. In this sense, the agency is acting like a court when the latter adjudicates, i.e., resolves disputes. The dispute resolution power of the agency is therefore called a quasi-judicial power. The phrase quasi-adjudication refers to a written decision of an administrative agency that resolves a legal dispute in a manner that is similar to the way a court solves such a dispute. An agency exercises its quasi-judicial power at several levels. At the first level is a hearing, which is similar to a trial in a court of original jurisdiction. The presiding agency official, known variously as hearing examiner, trial examiner, or administrative law judge, ALJ, will, like the judge in a trial court, take testimony of witnesses and other evidence, determine the facts of the case, and apply the law to those facts in order to render a decision. In many agencies, the findings of fact and the decision of the hearing officer constitute only a recommendation to the director, commissioner, secretary, or other high official who will make the decision at this level. Like the courts, many agencies then provide a second appellate level where a body such as a board or commission reviews the decision of the hearing examiner or other official to correct errors. After the parties to the dispute have used all these avenues of redress within the agency, they have exhausted administrative remedies, and may then appeal the final administrative decision to a court. Later, in Chapter 10, we will take a closer look at the dispute resolution function of an agency. Here is an example of an agency using all three powers. Securities and Exchange Commission SEC. Execution. The SEC accepts filings of registration statements containing financial data on issuers of securities. This is done to carry out the statutes of Congress requiring such registration. When an agency carries out a statute, it is administering or executing that statute rulemaking. The SEC writes regulations that provide greater detail on what the registration statements must contain. Dispute resolution. The SEC holds a hearing to decide whether a corporation has violated the registration requirements laid out in the statutes and administrative regulations. The end product of the hearing is often an administrative decision. Exhaust administrative remedies to go through all dispute-solving avenues that are available in an administrative agency before asking a court to review what the agency did. Assignment 6.4. Give the name, street address, phone number, fax number, email address, World Wide Web address, and function stated briefly of 3 federal agencies with offices in your state. B. 5 state agencies in your state. C. 5 city or county agencies with offices in your city or county. R. Section E. The legislati/T process. The legislative process consists of the steps that a bill must go through before it becomes a statute. A bill is simply a proposed statute. Exhibit 6.5 outlines these steps for the federal legislature Congress. The chart in Exhibit 6.5 assumes that the same idea for a bill is introduced simultaneously in both chambers of Congress, the House of Representatives, and the Senate. It is of course also possible for a bill to be introduced in one chamber, go through all the steps for passage in that chamber, and then be introduced in the other chamber. The conference committee step, outlined in the chart, occurs only when both chambers have enacted their own version of the bill. Congress is bicameral, meaning that it consists of 2 chambers, the House of Representatives and the Senate. In some state legislatures, the chambers have different names, such as the Assembly and the House of Delegates. Legislatures with only one chamber are called unicameral. The only state legislature that is unicameral is the Nebraska legislature. Local legislatures, however, such as city councils, are often unicameral. The process of enactment can involve 6 major stages: proposal, initial committee consideration, floor debate, conference committee consideration, floor debate, response of the chief executive. The legislative history of a statute is what occurs at each of these stages. A proposal, a member of the legislature must formally introduce the bill. Where do the ideas for proposed laws originate? There are many possible sources. The chief executive of the government, for example, the president or governor, may initiate the process by sending the legislature a message stating the reasons for a proposed law. Frequently, an administrative agency has made a study of a problem, which is the Bill A, proposed statute. Bicameral, having 2 houses or chambers in the legislature. Unicameral, having 1 house or chamber in the legislature. Legislative history, all of the events that occur in the legislature before a bill becomes a statute. F(WN) 8S2 vertical bar 5HT3 CF 3I plus O 1 1 mg less than DIIIGG 5 to 2H ES XSS F voted Ripper 1 and Southeast 3L L less than 81 S I asterisk ECCR 01R IOOE less than 5E 75 NSOU greater than underscore E.E CFR H CO 3 ear plus A SSE O less than UJ greater than rho 11 SJ AESTE 0.5361 PECFD CO SNFC CO LS 5I0 greater than E less than OQ 5230 plus O E less than I FG 5C a 55 of Electrobill Southeast LSAOPOQ EO C9 greater than O 1 GKT O.OOZ.I2OEC S O 0013 T5 RL C ESSSFSISO vertical bar 8 5 C vertical bar OS 0 0 SE to C 0 UOJD 1 pound J 5 CCD L ILN 1 equal 1 equal 0 0 S percent MWI GQ SG 05 T OC TR equal SCL plus CJ underscore 0 OJ1 U1 greater than ACD NJBO 1 LLE minus 210 I2 EU 111 1 Lee asterisk F SIS1 N0 I0 CEF /E 1 J underscore ELO T OOE SOS CO W B U D S10 2 FCDG id greater than 05 Q greater than less than Fe. Impetus for the proposal. The agency will usually be the entity with responsibility for administering the proposal if it is enacted into law. The Bar Association might prepare a report to the legislature calling for the new legislation. The legislature or chief executive may have established a special commission to study the need for changes in the law and to propose changes where appropriate. The commission might consist of members of the legislature and outside experts. Some states have ongoing law revision commissions that frequently make proposals for legislation. In many areas, a council of governments, made up of neighboring governments, studies problems, and proposes legislative changes. The National Conference of Commissioners on Uniform State Laws, AWU.NCUZL.org, is an organization with members from each state. The conference makes proposals to the state legislatures for the enactment of uniform state laws, where it deems uniformity to be desirable. Finally, the idea for the legislation may come from within the legislature itself. One or both houses may have established an investigating committee to examine a particular problem and propose legislation where needed. Individual legislators can also propose bills. Can private citizens propose a bill? Usually not. They must convince an individual legislator to introduce or sponsor their idea for a bill. B. Initial committee consideration. When a member of the legislature introduces a bill, he or she usually accompanies it with a statement on why the bill should be enacted. As bills are introduced, they are assigned a consecutive number, e.g., S-250 is the 250th bill introduced in the Senate during the current session. H.R. 1753 is the 1753rd bill introduced in the House of Representatives during the current session. Once the bill is introduced, it follows a similar procedure in each chamber. The bill is sent to the committee with responsibility over the subject matter of the bill. For example, a bill to change the criminal law might go to the Judiciary Committee. The initial draft of the bill might be considered by this committee and by one of its subcommittees. Hearings are held. Citizens and public officials give testimony for or against the bill. In some legislatures, this testimony is transcribed so that a word-for-word record is available. Legislators often propose amendments to the bill, which are voted on by the committee. The committee then issues a report summarizing why the bill is needed and what its major provisions are. If there is disagreement on the committee, a minority report is often prepared. C. Floor debate. The bill with its accompanying report S then goes to the floor of the chamber of which the committee is a part. The bill is debated by the full chamber. During the debate, which will usually be recorded or transcribed, members ask questions about the meaning of certain provisions in the bill, what is covered and what is not. Amendments are often made from the floor and voted upon. D. Conference committee consideration. Because both chambers act independently of each other in considering the bill, it is rare that they both produce exactly the same bill. Inevitably, the amendment process leads to different versions of the proposed law. To resolve these differences, a conference committee is established, consisting of key members of both chambers, such as the chairpersons of the committees that initially considered the bill, or the members who first introduced or sponsored the bill. A compromise is attempted in the conference committee. Amendments are considered, and a final report of the conference committee is issued. Dissenting members of the committee might prepare a minority report. The majority report summarizes the major terms of the compromise and explains why it should be enacted by each chamber. E. Floor debate. The conference committee compromise then goes back to the floor of each chamber, where more debate, explanations, and amendments are considered. Again, everything is recorded or transcribed. If both chambers pass the same version of the bill, usually by a majority vote, it goes to the chief executive. F. Response of chief executive. There are three main ways for the bill to become law after it reaches the chief executive. First, he or she can sign it. Second, the chief executive can do nothing. If the legislature stays in session for at least 10 weekdays. Veto an explicit rejection by the chief executive of a bill passed by the legislature. Override to supersede or change a result. To approve a bill over the veto of the chief executive. Pocket veto. The chief executive's silent rejection of a bill by not acting on it within 1 weekdays of receiving it if the legislature adjourns during this period. After he or she receives it, the bill automatically becomes law without requiring a signature. Third, if the chief executive rejects or vetoes the bill, it can still become law if both chambers of the legislature override the veto by a 2/3 vote. There are two main ways for the chief executive to reject a bill. First, he or she can explicitly veto the bill. It then goes back to the legislature, often with the chief executive's reasons for the rejection. Second, he or she can do nothing. If the legislature adjourns within 10 weekdays after the chief executive receives it, the bill automatically dies. This is known as a pocket veto. Because the legislature is no longer in session, the pocket veto deprives the legislature of the opportunity to override the veto. Assignment 6.5 Redraw Exhibit 6.5 so that your chart includes the steps needed for a bill to become a statute in your state legislature. B. Give the name, street address, phone number, email address, and fax number of the chief legislator in each chamber of your legislature, e.g. Speaker of the House, President of the Senate. If your state legislature is unicameral left bracket Nebraska right bracket, answer these questions for the one chamber that exists. C. What is the World Wide Web address of your state legislature? On this site, can you find current statutes in the code? Current bills in the legislature. Explain what is available. D. What is the full name of the legislative committee in each chamber, e.g. Judiciary Committee, with primary authority to consider laws that directly affect your state courts, such as procedural laws that govern the conduct of litigation. Give the name, political party, phone number, email address, and fax number of the current chairperson of each of these committees. E. What is the name of the local legislature in your city or county? Give the name, street address, phone number, email address, and fax number of the chief legislator of this body. If you have both a city and a county legislature, answer this question for both. F. What is the World Wide Web address of your local city legislature? Of your local county legislature? On these sites, can you find current ordinances or other laws in force, current bills in the legislature? Explain what is available. I Chapter SUK 4 MARY. Our legal system consists of 3 levels of government: federal, state, and local, and 3 branches of government: executive, legislative, and judicial, within each level. Federalism is the division of powers between the federal or national government and the state governments. To keep any one branch from becoming too powerful, our system imposes checks and balances among the 3 branches. There are 10 main categories of laws: opinions, statutes, constitutions, administrative regulations, administrative decisions, charters, ordinances, rules of court, executive orders, and treaties. In a special category are opinions of the Attorney General. These laws are written by one of the 3 branches of government: legislative, executive, and judicial, that exist within the 3 levels of government: federal, state, and local. Ours is a common law legal system. The main definition of common law is judge-made law, in the absence of controlling statutory law or other higher law. The method of resolving legal disputes is adversarial. The opposing sides go before a neutral decision maker, who listens to the arguments of each side before rendering a decision. An understanding of jurisdiction is key to understanding our judicial system. To render a decision, a court must have jurisdiction over the person's personal jurisdiction, or over the particular thing raised involved in the litigation, e.g., in rem jurisdiction. The court must also have subject matter jurisdiction, which specifies the kinds of cases over which a court can exercise its power. There are 6 main kinds of subject matter jurisdiction: limited, general, exclusive, concurrent, original, and appellate. Courts of original jurisdiction are the trial courts. There may be 2 levels or tiers of trial courts within a judicial system. There may also be 2 levels or tiers of courts with appellate jurisdiction. There are 3 kinds of administrative agencies: executive department agencies, independent regulator agencies, and quasi-independent regulator agencies. Government corporations are special entities that are a mixture of corporation and government agent. Agencies serve 3 main functions: to carry out statutes and executive orders, to write rules and regulations, and to resolve disputes that arise under laws for which the agency has responsibility. The federal legislature, Congress, and most state legislatures are bicameral. That is, they consist of 2 chambers. For a bill to become a statute, it must go through approximately 6 stages. First, the bill is proposed by being introduced into one of the chambers of the legislature. It may be introduced into the other chamber simultaneously, or at a later date. Second, a committee of each chamber gives the bill initial consideration. If the committee votes in favor of the bill, it goes to the next stage. Third, all of the members of one of the chambers debate and vote on the bill, and then all of the members of the other chamber debate and vote on the bill. Fourth, a conference committee, usually made up of members of both chambers, considers the bill. The role of this committee is to try to reconcile any differences in the two versions of the bill passed by each chamber. Fifth, the bill goes back to the full membership of each chamber for a vote on what the conference committee produced. Sixth, the chief executive signs or vetoes the bill. If he or she explicitly vetoes the bill, it can still become a statute if 2/3 of each chamber vote to override the chief executive. The legislative history of a statute consists of what happens during these 6 stages. Key terms: federalism, legislative branch, executive branch, judicial branch, opinion, statute, constitution, administrative regulation, administrative decision, charter, ordinance, rules of court, court rules, executive order, treaty, opinion of the attorney general, checks and balances, judicial review, common law. Civil law system at common law precedent, stare decisis, cause of action, adversarial jurisdiction, adjudicate, personal jurisdiction, in rem jurisdiction, subject matter jurisdiction, limited jurisdiction, general jurisdiction, state questions, federal questions, exclusive jurisdiction, concurrent jurisdiction, original jurisdiction, appellate jurisdiction, inferior court, appellate brief panel, and bank court of final resort, United States District Court, United States Court of Appeals, United States Supreme Court, administrative agency, executive department, agency, independent regulatory agency, quasi-independent regulatory agency, government, corporation, quasi-legislation, quasi-adjudication, administrative law judge, exhaust administrative remedies bill, bicameral, unicameral, legislative history, veto, override, pocket veto. 298, ilat till iakai.ki until ugai. System on the net. More on our legal system, understanding the federal courts, www.uscourts.gov/about.html. National Center for State Courts, www.nxconline.org. How our laws are made, Congress, www.thomas.lock.gov/home/holem.txt, www.law.pit.edu/infanti/howlaws.htm. How a bill becomes a law, example of state legislation. Michigan, www.senate.state.me.us/gov/resources/howabill.htmi. How a bill becomes a law, example of county ordinances. Baltimore, www.baltimorecountycouncil.org/howbill.htm. Administrative agency links. Federal, www.abscomtech.com/frn/agency.html. www.federal.gov. Administrative agencies. State and federal, www.law.cornell.edu/topics/administrative.html. State and local government on the net. www.piperinfo.com/state/index.cfm. Notes 1. Plus the District of Columbia, which has a special status, but in 4. In this context, the word / or /, means United States. The United, some respects, is treated as a state. States government is the federal government, the United States too. William Burnham, Introduction to the Legal System of the United States Courts, are the federal courts, etc. 78 2d ed. 1999. 5. The United States Court of Appeals, for the Federal Circuit also. 3. If a court's judgment is binding only on designated individuals, who reviews cases from other special tribunals, such as the United, have an interest in the raise rather than on everyone, with such an in state's patent and trademark office, and the international trade. Tourist, the court had quasi-in rem jurisdiction to render the judgment. Commission. The judgment is binding only on the designated individuals. The Skills of a Paralegal. Contents. Chapter 7 Introduction to Legal Analysis. 301 Chapter 8 Legal Interviewing. 331 Chapter 9 Investigation in a Law Office. 367 Chapter 1 Litigation Assistantship. 407 Chapter 1 Legal Research. 453 Chapter 1-2 Legal Writing. 627 Chapter 1-3 An Introduction to the Use of Computers in a Law Office. 655 Chapter 1-4 Introduction to Law Office Administration. 689 Chapter 1-5 Informal and Formal Administrative Advocacy. 717 Introduction to Legal Analysis Chapter Outline A. Introduction B. The structure of legal analysis. C. The element identification. Skill D. The issue statement. Skill E. The definitions. Skill F. Factor analysis. G. Briefing court opinions. H. Applying court opinions. P. Earl Till skills. Alapakal legal analysis. The application of one or more rules of law to the facts of a client's case in order to answer a legal question that will help 1. Keep a legal dispute from arising, 2. Resolve a legal dispute that has arisen, or 3. Prevent a legal dispute from becoming worse. Also called legal reasoning. Section A. Introduction. Throughout society, people constantly apply rules to facts. For example, when Fred tells his soon-to-be 17-year-old daughter, "We can't afford that car for you," he is applying rules to facts. In this instance, the rules are budgetary rules on how household funds are to be spent. The facts consist of his daughter's desire to have a particular car on the dealer's lot. When she responds, "But you allowed Tommy to have one like that when he turned 17, the discussion will probably heat up and focus on fairness rules that may or may not have been part of this family's history. The vast majority of rule applications and rule conflicts in our society never enter the legal system. Most disputes are settled privately or are simply ignored. Fred and his daughter will not be resolving their car dispute in court. While our focus in this chapter will be those disputes that do enter the legal system, the method by which the law resolves such disputes is quite similar to the way in which rules are applied to facts in all kinds of conflict throughout society. There is no magic process of conflict resolution used in the law. The process that the law uses may, at times, be complicated, but it is remarkably similar to how every other segment of society identifies its rules and resolves its conflicts over them. Attorneys become involved only when rules of law are applied to facts that raise legal disputes. In this arena, the heart of what the attorney does is called legal analysis, or legal reasoning. It is the application of rules of law to facts in order to answer a legal question or issue. There are 3 related goals of legal analysis: to keep a legal dispute from arising, to resolve a legal dispute that has arisen, and to prevent a legal dispute from becoming worse. Paralegals need to study legal analysis for 2 main reasons. First, many paralegals are given assignments that in varying degrees call for legal analysis. Secondly, and perhaps more importantly, since attorneys talk the language of legal analysis all the time, issues, rules, elements, briefing, reasoning, etc., a paralegal who knows the basics of legal analysis will be better equipped to understand and communicate with attorneys. Section B. The structure of legal analysis. The flow of legal analysis is demonstrated in the following chart, containing a relatively simple example. 10. Any business within the city must apply for and obtain a license to do business within the city limits. Bill and his neighbors in the city have formed a food co-op, through which members buy their food collectively from a wholesale company. All funds received by the co-op go for expenses and the purchase of more food to sell. Is a food co-op a business, within the meaning of 10, requiring a license to do business? The city argues that the co-op is a business in the city. The co-op concedes that it is in the city, but argues that it does not do business, since the co-op does not earn a profit. The co-op has the better argument. 10 was not intended to cover non-profit ventures. Hence the co-op does not have to have a license. Note the process. Use care with a specific rule, such as a statute or regulation. For the definition for these and other categories of rules of law, see Exhibit 6.1 in Chapter 6. You quote the relevant language exactly. You state the major facts. You phrase the legal issue in terms of specific language in the rule and specific facts that raise a question or controversy. You draw the connection between specific language in the rule and specific facts. The substance of the analysis is this connection. Another term for connection is application, applying the rules to the facts. You reach a conclusion based on these steps. Here is a more detailed statement of the analysis, referred to as the connection, in the chart. Section 10 provides as follows. Any business within the CIC must apply for and obtain a license to do business within the CM limits. There are 2 main elements of 10. 1. Any bus must do Within the city, when the facts fit within these two elements, the entity in question must apply for and obtain a license to do business. The consequence of the rule is the need to be licensed. This consequence is mandated once both elements apply to the facts. 1. Any business. The cit claims that the co-op is a business. It does not matter to the city that the co-op does not earn profits in the traditional sense. According to the city, the co-op members are selling goods to each other. A business is any entity that engages in any form of selling. The co-op, on the other hand, argues that 10 was not intended to cover co-ops. A business is an enterprise that makes a profit over and above expenses. Nothing of this kind occurs in the co-op. Everything taken in by the co-op goes out in the form of food purchases and expenses. Hence, the co-op is not a business and does not have to have a license to. Within the city, there is no dispute between the parties on this element. The CM and the co-op agree that the co-op operates within the city limits. The only dispute in this case concerns the first element, whether the co-op is a business. If you had included legal research data on the meaning of 10, the analysis might have contained a discussion of court opinions, if any, that interpret 10, a discussion of administrative regulations, if any, that implement 10, a discussion of the legislative history, if available, of 10. A discussion of constitutional provisions, if any, that affect the applicability of 10, a discussion of secondary authority, if any, that interprets 10, such as legal periodical literature and legal treatises. Later, we will be examining opinions, regulations, legislative history, constitutional provisions, and secondary authority in greater detail, particularly in Chapter 1.1. The structure of legal analysis has 4 components. To remember them, use IROC as a guide. IROC is an acronym beloved of generations of attorneys who were introduced to IROC during their first year of law school. Watch the smile on the face of supervising attorneys when you tell them that you've studied IROC. The acronym IROC stands for Issue, Rule, Application, or sometimes Analysis and Conclusion. Issue. Identify the legal issue to be resolved in the client's case. Rule. State the portion element of the rule that is at the center of the dispute application, connecting facts to the elements of a rule in order to determine whether the rule applies to the facts. Explaining how the element of a rule applies or does not apply to the facts. IROC, an acronym that stands for the components of legal analysis. Issue I, Rule R, application of the rule to the facts A, and conclusion C. A structure for legal analysis. 10. Skills of a par/s legal memorandum of law. A written explanation of how the law might apply to the fact situation of a client. Application. Apply, connect the rule to the facts of the client's case. Do this from the perspective of the client and from the perspective of the client's opponent. The latter perspective is the counter-analysis, which is the position of the other side on how the rule applies to the facts. Conclusion. State the conclusion on whether the rule applies to the facts. If a problem in the client's case involves more than one issue, each is IROC'd in the same manner. IROC can be used in memos, in essay exam answers, or in your head. In short, whenever you are doing legal analysis. If you write out your analysis in a law office, you usually do so in a document called a memorandum of law, also called a legal memorandum. See Chapter 12. Often the memorandum of law, memo for short, is organized in 4 parts corresponding to the 4 components of IROC. Some of the essay examinations you take in school can follow the same organizational format, although your examination answer may not be as formally structured as a memo. Even less formal will be the legal analysis you will do in your head. Whenever and wherever you do legal analysis, you can use the same analytical IFIAC structure. Keep in mind, however, that IROC is only a guide. There is no rigid formula for doing legal analysis. What is important is to make sure that you cover the essentials somewhere in your analysis. The essentials are issue, rule, application, connections, and conclusion. Let us look at another example. Assume that a statute 12 provides that additional punishment can be imposed when a weapon is used by a defendant in the commission of a drug offense. John Smith is convicted of selling heroin to his brother. When John Smith was arrested, the police found a gun in his back pocket. The question is whether he can be subjected to additional punishment under 12. Here is a skeleton overview of how this problem might be analyzed with Iraq as a guide in a memorandum of law. Before going through Iraq, note that we begin with a statement of the facts. Later in Chapter 12, we will cover some of the other components of a memorandum of law. Facts: on December 12, 2002, John Smith was arrested at 465 East 8th Street, South Boston, at midnight. He was observed selling a substance to another adult, his brother Richard Smith. The substance was later determined to be heroin. When John Smith was arrested immediately after the sale, Officer Frank Doyle searched him and found a gun in his back pocket. Doyle was not aware of the presence of the gun until this search. At the trial, Smith was convicted of selling heroin. During sentencing, the prosecution asked for additional punishment because he used a weapon in the commission of a drug crime. Smith objected on the ground that he did not use the weapon under the applicable statute. Issue: has a person used a weapon in committing a drug offense under 12 when he is found with a gun in his back pocket at the time he is arrested for selling heroin, even though the gun played no active role in the drug sale? Rule Section 12 provides as follows. A judge may impose additional punishment on a defendant when a weapon is used by the defendant in the commission of a drug offense. 12. Application: there are three elements of 12. 1. Weapon. 2. Is used. 3. In the commission of a drug offense, if these three elements apply, a judge can impose additional punishment on the defendant under 12. There is no dispute between the parties on the first and third elements. Both John and the prosecutor will agree that the gun found on John was a weapon, and that selling heroin is the commission of a crime. The question is whether John used this weapon in committing the crime. The parties will disagree over the definition of used. The prosecution will argue that it means having it in one's possession, ready for employment as needed. Under this definition, Smith used the gun. A person with a gun in his pocket possesses the gun. Furthermore, Smith was in possession of the gun while Smith was selling heroin. Hence, he used the weapon in the commission of a crime. Smith, on the other hand, will argue that the prosecution's definition is too broad. When the legislature passed 12, it intended used to mean actively employing a weapon in the actual commission of the drug offense for which the defendant was arrested. When Smith sold heroin to his brother, he never took out his gun. There is no evidence that his brother knew he was armed. John Smith never actively employed the gun by brandishing it, displaying it, striking anyone with it, or threatening to fire it. Hence, he never used the gun. Merely possessing it is not enough under 12. If the legislature had intended the word to mean mere possession, it could have used the verb possessed rather than used. If the weapon played no role in the commission of the drug offense, the legislature did not intend defendants to suffer additional punishment. Conclusion: Smith has the stronger argument. The word used suggests activity beyond passive possession. If relevant court opinions existed that interpreted 12, they would be included under the A component of Iraq to help us interpret the meaning of used in 12 in the Smith case. Similarly, this section of the analysis might include a discussion of other rules, e.g., constitutional provisions, if any, that affect the applicability of 1-2, a discussion of the legislative history, if available, of 1-2, a discussion of secondary authority, if any, that interprets 12, such as legal periodical literature and legal treatises. We will be returning to these themes later in the chapter, as well as in chapters 1 and 12. Our goal here is simply to introduce you to the essential structure of legal analysis through Iraq. We turn now to three skills that are very important to this structure. Element identification skill. This skill allows you how to break any rule into its elements. The first step in identifying an issue is to identify the elements of the rule that will be applied. Issue statement skill. This skill allows you to identify which elements of a rule are in contention. The second step in identifying an issue is to identify which elements of the rule will be in contention. Each element in contention will be the basis of a September R8 issue. Definition skill. This skill allows you to determine if an element in contention can be defined broadly and narrowly. The application of the element will cover these competing definitions. Mastering these 3 skills will go a long way toward equipping you to use Iraq in legal analysis. Section C. The element identification. Skill element A portion of a rule. Step 1 in applying a rule is to break it down into its pieces, or components. We call that as a precondition of these components elements. Before the consequences of a rule can apply, you must applicability of the entire, demonstrate that all of the elements of that rule apply. Rule. Rules have